How can a lawyer defend someone who's guilty? I'm Dan Ringer, and we'll talk about defending the guilty right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
When is someone guilty of a crime? My guests are attorneys and public defenders, Nancy Ulrich and Brian Kornbrath. Nancy, you're the Chief Public Defender in Harrison County, West Virginia.
That is correct.
And Brian, you're the Public Defender for the Northern District of West Virginia.
Yes.
So you've both been around the barn a couple of times.
Correct.
So how can you defend someone who's guilty?
Well, and I believe it's very easy to defend someone guilty, and I believe that we have a constitutional directive to represent anybody who's charged with a crime. And I have a colleague who would say that an individual isn't guilty until a jury says that that individual is guilty. However, under our Constitution provides that anyone charged with a crime or a Bill of Rights, that they are entitled to a representation. I think that also as a lawyer, I feel that I have a professional responsibility to defend an individual who's charged with a crime, and that is because of case law in West Virginia and also because of our rules of professional conduct and again, the Bill of Rights in the West Virginia Constitution, that everybody's entitled to legal representation whether they're charged with a crime. I also believe it's the right thing to do.
Brian, how do you do it?
Well, I think there's a distinction between the defendant who's innocent because there's a legal or factual defense, or a defendant who realizes that there's sufficient evidence to prove the case such that he or she decides to go forward and admit to the crime and plead guilty and try to mitigate the case through sentencing factors. So
that's interesting, that someone who may not be factually guilty would say, I am.
Well, I think that's the rare case, Dan. I think in the more common case, when you sit down and look at the physical evidence, the statements, confessions, the eyewitness testimony, a defendant may say, I agree, the state or the federal government can prove the case beyond a reasonable doubt, so rather than proceed to trial, I'll consider admitting to that offense. And that happens on a somewhat regular basis. The flip side, though, is that a person contests guilt because either they did it, but there's a legal justification, or they're convinced that the government can't prove the case to a jury of 12 beyond a reasonable doubt.
What do you mean by a legal justification?
Well, let's use an example. It's a bar fight. There's no dispute that the person punched the other person in the face, but self-defense is lurking there. I had no choice. I was threatened. I was cornered. I did what I had to do. If a jury accepts that explanation, it's a legal defense, and it would support a not guilty verdict if it went to trial. That's just one example.
I've always found that just because someone's charged with a crime doesn't mean you know what happened or what it means, that there are a lot of questions to ask. One of the first questions I always ask is, tell me what happened.
Sure.
I think that's one of the roles of a defense attorney. I think I always see my job as actually making sure that the prosecution or the prosecutor has good, solid evidence, that a person isn't charged or on evidence that could be, let's say, not good evidence, where I think that eyewitness testimony, I think probably everyone is aware of eyewitness testimony and how credible eyewitness testimony is or is not. But someone who's seeing something from 300 yards away without their glasses, someone's trying to recall something that occurred a year ago, and I think everybody has heard of false confessions where, as Brian was saying, where people go in and will falsely confess to a crime that they really didn't commit. So I think one of the roles that I see as a defense attorney, that if an individual comes in, and I will tell you how I handle this. When someone comes in, as we know as attorneys, an individual is charged by means of a warrant and a criminal complaint. And I always ask, have you received a copy of the complaint? Have you read it? Do you understand it? So then I will say, tell me your side of the story. Tell me what you believed happened. So I will get some idea of what I need to be doing. But I think you, as a defense attorney, as I started to say, we have to make sure that the prosecutor really has solid evidence, that they don't have lying or untrue testimony. And then after you think that the evidence is solid, then you decide which direction you need to take your client from there, or your client will decide.
Evaluating evidence can be one of the hardest things that you have to do. Several years ago, several decades ago now, I was involved in a murder case where if you take the evidence as it was represented by the prosecution or the police, a fellow had a deer rifle. Another fellow was coming at him. The other fellow had a knife, so the guy with the deer rifle shot the guy with the knife because he didn't want to get stabbed. And on the face of it, that's arguably a murder case, although there are elements that could translate into self-defense in that, certainly. By the time the development of the evidence was done, it turned out the fellow with the deer rifle had been standing in his living room. The rifle was hanging on the wall. The other guy burst through the door, announced that he was going to kill the guy standing in his living room, and produced a knife, whereupon the guy in his living room pulled the deer rifle off the wall, which had one bullet in it. He didn't even have another bullet anywhere in the house, and he shot him and killed him. And the jury said, yeah, that's okay. Under those circumstances, that's okay. But if you just take the facts as are originally represented, maybe not.
That's great. And I've even, in a lot of cases that I will have in the state court, is that we actually will resort to having to get expert witnesses to help us evaluate evidence, and you can have a totally different result than what the individual may be indicted for. It may be a different degree, and as you have a entirely different result. But we will always go to the scene, look at the scene. We'll interview the witnesses that the state has interviewed, and it's really interesting if time passes, how that individual, even though it's been the state's witness, how that what they saw, what they told the state, how that will change, because they've had time to think about it, they've had time to reflect, and it might be a bit different. And we will also find other witnesses. But every time, very often, I can't say in every case, but very often the cases will not be completely investigated. It is just a partial investigation, and it takes just some digging deeper. And we've gotten cases dismissed just on a better investigation. We have an investigator in our office that we use, and so we've actually had cases dismissed just because we had a better investigation done.
Well, it's important, I think, to point out that both of you represent people accused of crimes who cannot afford an attorney otherwise. Brian in
Correct.
The federal system, Nancy, you in the state
That's
system.
right.
Why do you think cases are not thoroughly and completely investigated?
I think it's time and resources. If it's a quickly unfolding event and the officers are at the scene and they have to make split-second decisions, they make those decisions. But further investigation, follow-up investigation, forensic testing that Nancy mentioned, all that can come into play later to shed more light on a case. And what's important to note, too, is not only do you have a right to a court-appointed lawyer if you can't afford private counsel, but there's the corollary right that you have available investigators, forensic experts, mental health professionals. If your case requires that type of service to mount a defense, we as a society have deemed it important enough that you get that resource.
You say mount a defense and using mental health professionals. How would mental health professionals identify a defense about something that supposedly happened?
Sure, there's two areas that come up on a somewhat regular basis. One is whether or not the defendant is even legally competent to go forward in the criminal case. Can he or she assist in their defense? Do they understand the nature of the charges, or is there a mental illness lurking there that precludes a finding of competency? Courts will not allow a criminal case to go forward if that's present. Insanity or mental disease or defect could be another legal defense to the charges, and that certainly requires a mental health professional. Attorneys aren't able in and of themselves to proceed down that path.
We're talking about defending the guilty client. My guests are attorneys Nancy Ulrich and Brian Kornbrath. Both are public defenders. I'm Dan Ringer, and this is The Law Works. The history of mental illness as a defense is, well, it's full of twists and turns. And
Very
it's
much so,
developed a
sure.
lot. It's really beyond the purview of this program to talk about that. But those are things that need to be looked at, and those are things that the police in their investigation really never look at.
Right, and when I say forensic experts, I don't mean just mental health. It could be fingerprints, DNA, ballistics. There's all kinds of science that's used to try to prove up a case nowadays.
Well, unfortunately, and in this series over the 12 years we've been doing The Law Works, we have had occasion to mention many times a very unfortunate chain of events that involved a forensic scientist by the name of Fred Zane, who was a state police chemist. And Mr. Zane simply made up test results designed to result in convictions. He lied, in essence. Nancy, Brian, have you ever had police officers lie in cases that you're involved in?
Oh yes, we have had that. We have actually had incidents whereby police officers have actually themselves been charged with crimes, and therefore then the state prosecuting these particular cases will not proceed on those cases, and they will get dismissed. I can think of two incidents off the top of my head right now, but we've actually had a police officer went to prison for a very serious charge in our area. I just was wanting to follow up, if I may just briefly, with what Brian said. Also, not only do you deal with competency, but criminal responsibility, because some people are so mentally ill they cannot appreciate that they're committing a crime. Now, I also want to add that, just so I don't forget to do this, I guess that in this, everybody who has a label or who's charged with a crime, who even goes as far as being indicted with a crime, can be very innocent of that crime. Innocent people are charged with crimes. That is a reality. And so that is why another reason you protect all of society, criminal defense attorneys protects all of society. And I have this firm belief that we also protect our Constitution and provisions in our Constitution by doing a good job as a criminal defense attorney.
One of the things that we hear in various formulations is that it's better to let 99 or 50 or 200 or however many it is, guilty people go free than to convict one innocent person. That sounds great, and it's a high standard. Do we really do that? It has always seemed to me that we're more likely to convict an innocent person rather than letting a guilty person go free.
Well, there's been a lot of publicity lately when it comes to what's called the Innocence Projects, where years ago, because of eyewitness testimony and possibly even forensic evidence, someone's been convicted of a crime, and then years later, DNA exonerates them completely. They could not have committed the crime. So it's certainly possible. In addition to, you mentioned the example of the lying police officer. I think that's rare. It happens, but it's very rare. But at the state and federal level, we're also responsible for, call it quality control, making sure that the police follow the Fourth and Fifth and Sixth Amendment rights that everyone has. And if those rights are violated and you can prove that claim to a court, you can have evidence suppressed, you can have statements suppressed, you could have cases dismissed if there's sufficient grounds of misconduct.
Who do the police represent?
The public. And let's be honest, I mean, if everyone that was arrested came into court and was found to be factually innocent, the system's not working right. Many people that get arrested by the police are in fact legally and factually guilty. And in reality, many of our clients, because they realize the case can be proved, there's solid evidence against them, they'll stand up in court and admit to the wrongdoing. And many of them have remorse and they're willing to accept their punishment. Our job at that point is to try to mitigate, explain, not excuse, but explain what happened and try to get drug treatment, counseling, a lesser prison sentence in exchange for strict conditions of supervision. So just because someone is legally guilty doesn't mean the defense attorney stops working.
Yeah, in fact, a big part of your job as a defense attorney, of our job, because I do it too, is after the client has said, okay, I did it, or a court finds that the client did it.
Right.
In fact, in many aspects, you become almost social workers and part of the defendant's support structure.
Very much so. I mean, there are certain areas that a defendant in a criminal case has complete control over. And one of those is whether or not to plead guilty, whether or not to have a jury trial, whether or not to take the stand and testify, whether to take an appeal if you're convicted. There are certain fundamental rights that the defendant has complete control over. Everything else, though, is pretty much deemed a tactical or strategic decision that the lawyer is responsible for. And that's pretty much the nuts and bolts of any criminal case.
I'm sorry, Nancy, go ahead.
I was just going to go back to whether or not police officers lie. I would say also that some police officers, the investigations are not done well because they've not been trained well. I think anyone who has practiced law in this field for any period of time, if you have an officer who's been an officer for a while, he's going to be much better. And I think if you have a good defense bar, and I see this having been at Clarksburg now for some time, you teach the police officer to be a better police officer as a defense attorney, particularly when it comes to taking statements and don't talk to my client. They become a better police officer. In fact, a good defense attorney has a good working relationship with the police agencies in your area, and I would say our office does that. But I think some of the officers just are not trained well. But also, but I'm thinking more in terms of misdemeanor offenses, that police officers will go out, I'm safe, and I'm thinking particularly in a domestic case, they really come after the dispute's over. They don't know who. I mean, sometimes it's very obvious who may have been the victim, who may be the perpetrator, but sometimes they don't know, so they arrest both people. And then it's left up to the defense attorney to say, you know, where's probable cause here? But anyhow, to determine who really ought to have been charged. But the other, I was just wanting to say that as Brian was talking about pleading, one of the big problems is overcharging individuals. And when you plea an individual, you have to be very certain that he's actually pleading to the charge that you're comfortable that he offended and did that charge. But you have to be very careful for overcharging.
We're talking about defending the guilty client. My guests are attorneys Nancy Ulrich and Brian Kornbrath. Both are public defenders. I'm Dan Ringer, and this is The Law Works. I have found over the years, I've been practicing law now for 32 years, and I have found that by and large, most police officers are honest people. They want to do it right, but for whatever reason, maybe it's a lack of training, maybe it's an inability to discern the fine nits. They're not lawyers. Mm-hmm. So they make mistakes, and a few lie. I've had police officers lie in matters that I've been involved in, everything from being able to see a stoplight to determine whether somebody ran the light when it was red or green, up to the test results are this way when in fact they're actually that way. Sometimes it's a result of not having the resources to do
Right.
the investigation. Sometimes it's a desire in the belief that somebody really is guilty to just make sure that the guilty person gets convicted.
And there are certain safeguards in place to ensure that that doesn't happen on a regular basis. For example, if you're going to have an arrest warrant or a search warrant served, it's got to go through a judicial officer who reviews the evidence and makes sure that there's probable cause to go forward. You know, the officers have to operate within the law, but it's a complicated area and it's always changing. Criminal procedure is not an easy concept, and you can have a police practice that's been legal for years, and then suddenly the Supreme Court or a West Virginia court comes out and says, no, we're going to change the law, and it's different. For example, for years, if someone was arrested while driving their vehicle, put in the back of a cruiser, officers had a right to go and search the entire vehicle. And a couple years ago, the Supreme Court came out and said, no, if that person doesn't have true access to the vehicle, you can't do that. So there was just a huge sea change in the law, and that happens on a somewhat regular basis.
And that it kind of circles back to where we started. Probably the one question you don't want to ask your client when you originally meet them is, are you guilty? Because I've typically found that one of the worst judges of whether someone is guilty is the person who's accused of having committed the act.
Sure.
Because they just don't know. If somebody has never heard of the concept of self-defense, they may be racked with guilt because they did something that killed somebody and inclined to say, yes, I'm guilty, and may have even confessed to the police by saying, yes, I killed her or him or whatever it was. And that's not exactly true. I was involved in one murder case where the police officer testified. The defendant gave a statement. When asked, did you kill this person? She said, yes, I killed him, and she cried. On cross-examination, the question was put to the police officer, did the defendant say anything else before you took the statement? And the answer was, oh yeah, she came into the office, she was crying, she was horribly upset about it. The first thing she said was, I didn't mean to kill him. I said, well, how come you didn't put that in your statement?
Sure.
And the response was, I hadn't turned on the tape recorder yet. This is just a transcription of what was in the tape recording. Now, to his credit, he was honest and said that, but the prosecutor didn't know that that had been said, so the prosecutor didn't ask about it, and the cop certainly didn't volunteer about it because he'd been told not to volunteer information. And the person obviously was upset, so she thought she had committed a murder. She was, in fact, stone innocent.
Sure.
Because she was defending herself.
I mean, our job is to evaluate the evidence and give advice. Do we go to trial or do we plead guilty? That's the client's decision to make. And I'll be the first to admit it. I've had a number of cases where I looked at the quality and nature of the evidence. My opinion was, I think a jury of 12 will convict you. We went to trial and the person was found not guilty.
Yes, I've done that.
But it's their choice. All you can do is give advice and try to evaluate the nature and quality of the evidence, but the final decision has to be up to the client.
Nancy, do you decide if your client's guilty?
Well, you know, realistically, you cannot go through this whole process and not come up with some idea whether or not your client's guilty. But again, it's what is he or she guilty of? Is it a lesser included offense, or and if so, is there some reason why this really may have occurred? I say, as I said to my client, tell me your side of the story, but I also add to that, please tell me everything that you can remember. When you get home, you think about it, you write it down, because I don't want to come up with some information if we decide to go to trial that I don't know about and that I cannot help defend you with that information at trial without having known it beforehand. So, you cannot go through the whole process without having an idea what your client's position is.
You form an opinion.
Right, that's correct.
And there's an important point to make, and that's that lawyers on both sides, prosecutors and defense attorneys, are bound by what are called rules of ethics. We cannot, in good faith, put a client on the stand if he or she is going to intentionally commit perjury. It's just not allowed. So there's all kinds of levels there.
Right.
Sure.
Well, I was working as a prosecutor some years back, and a defense attorney came in, and when I explained to him why his client was guilty and what I thought of that evidence, he said, "But you're supposed to presume that my client is innocent." I said, No, you've got me confused with the jury. The jury is supposed to presume that your client is innocent. I'm prosecuting him. If I didn't think he had done it, I wouldn't be prosecuting him because I have a duty not to prosecute people that are apparently innocent and that shouldn't be prosecuted.
That's very interesting when you talk to different defense attorneys and their approach, because as I said, one of my colleagues will always say, and if you happen to say, you state an opinion, he'll say he's not guilty until a jury proves it. And
Nancy Ulrich, Brian Kornbrath, thank you very much for being with us. Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening.
On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.